年香港藝術發展局修訂條例草案》。
本會現在恢復2013年稅務修訂條例草案二讀辯論。審議條例草案嘅委員會主席梁繼昌議員會就委員會嘅報告向本會發言。梁繼昌議員。
Mr. President, in my capacity as Chairman of the Bills Committee on Inland Revenue Amendment Bill 2013, I wish to report on the work of the Bills Committee. I shall focus on the major issues considered by the Bills Committee. The main objects of the bills are, first, to put in place a legal framework for Hong Kong to enter into tax information exchange agreements with other jurisdictions, and secondly, to enhance the existing exchange of information arrangements under comprehensive avoidance of double taxation agreements in respect of tax types and limitation on information disclosure. The purpose for introducing the changes is to meet the latest international standard for exchange of tax information. The Bills Committee generally supports the proposals in the bill in view of the importance of Hong Kong to maintain its reputation as an international business and financial centre committed to upholding tax transparency and combating tax evasion, and to be able to pursue comprehensive avoidance of double taxation agreements successfully with trading partners. In the course of deliberations, members have, however, expressed concerns about the extent of the relaxation of the limitation on information disclosure, the possible additional burden on taxpayers in respect of retention and reporting of tax information, the adequacy of the safeguards for protecting taxpayers' privacy and confidentiality of tax information exchanged, the oversight and scrutiny of the administration's compliance with the disclosure procedures, as well as the use of tax information for non-tax related purposes. One major proposal of the bill, Mr. President, is to allow the Commissioner of Inland Revenue to disclose tax information generated prior to the effective date of the relevant comprehensive avoidance of double taxation agreement, or, if applicable, the tax information exchange agreement, if he is satisfied that the information relates to the carrying out of the provisions of the relevant agreement or the administration or enforcement of the tax law of the requesting government's territory, in respect of any period that starts after the date on which the relevant agreement comes into operation. Although the administration has advised that the existing record-keeping requirements under the Inland Revenue Ordinance, which stipulate a 7-year period for the retention of business and rent records, will remain unchanged, some members of the Bills Committee are concerned that the proposal will allow a requesting tax authority to ask for information generated more than 7 years before the relevant agreement comes into operation. It has been suggested, Mr. President, that the administration should set a time limit on the period for which provision of retrospective information will be considered, or expressly confine such disclosure only to information that is necessary and direct for a specified purpose. The administration, in response to this demand, has explained that under both comprehensive avoidance of double taxation agreements and tax information exchange agreements, requests for exchange of information have to meet the standard of foreseeable relevance, which is a safeguard against fishing expeditions. In addition, under the Inland Revenue Disclosure of Information rules, the Commissioner of Inland Revenue will not entertain a request for information exchange unless he is satisfied, upon the examination of the particulars provided by the requesting partner, that the standard of foreseeable relevance, among other criteria, is met. The administration has advised that as far as the standard of the Organization for Economic Cooperation and Development, OECD, is concerned, the formulation foreseeable relevant has been adopted to mean necessary and relevant. Furthermore, even when the Inland Revenue Department acts on a valid exchange of information request and exercises its information gathering power to approach a person for the relevant information, the person has no obligation to provide to the department for exchange of information purposes. Information which is not in his possession or control and is not required to be kept or beyond the statutory retention period under the Inland Revenue Ordinance. Hence, the administration considers that there is no need to set a time limit on the period for the provision of retrospective information under the two agreements. Members of the Bills Committee are also concerned about the safeguards to be put in place under the bill and the future tax information exchange agreements to ensure that taxpayers' privacy and confidentiality of information exchanged are duly protected, and the Inland Revenue Department will not release information for inappropriate reasons. The administration has advised that after the legal framework for tax information exchange agreements is in place, in order to afford legal protection to taxpayers in terms of privacy and confidentiality of information exchanged, it will follow the current approach on comprehensive avoidance of double taxation agreements to strive to provide relevant safeguards in the text of the relevant tax information exchange agreement. These safeguards will include, among others, to exchange information only upon request, only to disclose information which is foreseeably relevant, to treat information received as confidential, not to disclose the information request to a third jurisdiction, etc. The administration has assured the Bills Committee that each comprehensive avoidance of double taxation agreement or tax information exchange agreement signed will be implemented as subsidiary legislation domestically, subject to negative vetting by the Legislative Council. The existing Inland Revenue disclosure of information rules, providing for domestic statutory safeguards in addition to those provided in individual agreements, will be extended and become applicable to exchange of information under both agreements. Some members also raised concerns in particular on the disclosure of information subject to legal professional privilege. The administration has advised that there is no obligation on a contracting party of either of the two agreements to supply information covered by legal professional privilege. The restriction on disclosure of legally privileged materials is legally binding on the Inland Revenue Department. Furthermore, it is stated in the commentary on the exchange of information article of the OECD Model Tax Convention that a requested jurisdiction may decline to disclose information relating to confidential communications between attorneys, solicitors, or other admitted legal representatives in the role as such and their clients to the extent that the communications are protected from disclosure under domestic law. On the handling of taxpayers' appeals on information disclosure, the Bills Committee notes that the Inland Revenue Disclosure of Information Rules has put in place a notification and review system in processing exchange of information requests and related appeals, such as the procedures for a taxpayer to make objection to the disclosure of or part of the information that the Commissioner of Inland Revenue is prepared to disclose to the requesting partner. There was a suggestion that the administration should put in place an independent oversight body to ensure that the Inland Revenue Department will deal with individual requests in a fair and consistent manner, and that the actions taken and decisions made by the Department would strictly adhere to internal procedures and guidelines. On this issue, the administration has explained to the Bills Committee that whether or not Hong Kong can pass OECD's evaluation on its compliance with the latest international standard for exchange of information in September this year will largely hinge on the availability of a legal framework for tax information exchange agreements. It is therefore critical to proceed with the proposals of the bill to put in place such a legal framework in a timely manner. Since the suggestion to set up an independent oversight body to monitor the Inland Revenue Department's compliance with the disclosure procedures will lead to some structural changes to the existing system, the administration considers it premature to take it forward in parallel with the proposals in the bill, without gauging the views of the concerned parties and the public. It will, however, seek improvements on the monitoring of procedural compliance in the long run. The Bills Committee notes that, to abide by a new requirement of OECD, the administration is prepared to allow future contracting parties of comprehensive avoidance of double taxation agreements to use the information exchange for non-tax related purposes. This does not involve, Mr. President, any amendments to the Inland Revenue Ordinance in the current legislative exercise. The non-tax related purposes for tax information exchange are to be governed by the terms of the relevant agreements. The administration has explained that under the latest version of the OECD Exchange of Information article, non-tax related purposes must be purposes for which the tax information exchanged may be so used under the laws of both parties to the relevant agreement. And the use of the information exchanged for such purposes must have the prior authorization of the competent authority of the supplying party. Moreover, OECD only allows the sharing of tax information by the tax authorities of the receiving party with other law enforcement agencies and judicial authorities in that jurisdiction on certain high priority matters, for example, to combat money laundering, corruption, and terrorism financing. The Privacy Commissioner for Personal Data has expressed concern that the use of tax information exchange under the comprehensive avoidance of double taxation agreements for non-tax related purposes may not be entirely consistent with the existing exemption provisions in respect of prevention and detection of crime under the Personal Data Privacy Ordinance. The administration has explained that on every future occasion of intended use of tax information for specified non-tax related purposes, the Inland Revenue Department will not consent, I emphasize, will not consent to the request of a contracting party if the relevant government departments in Hong Kong raise objection, or if such use of information is not covered by the current exemption as provided under Section 58 of the Personal Data Privacy Ordinance in relation to crime under the laws of a place outside Hong Kong with which Hong Kong has in place legal or law enforcement cooperation. The administration has advised that under the laws of Hong Kong, tax information may only be used for limited non-tax related purposes, such as recovery of proceeds from drug trafficking, organized and serious crimes, and terrorist acts. The administration has assured members that in signing new comprehensive avoidance of double taxation agreements in future, it will not accept the latest version of the Exchange of Information article lightly, unless both jurisdictions have similar legislation on use of tax information for non-tax related purposes. together with law enforcement cooperation arrangement in place between them. Mr. President, the Bills Committee supports the second reading of the bill. Neither the administration nor the Bills Committee will move any committee stage amendments. The following part of the speech carries my personal comments on the bill. As a personal observation, the bill enables Hong Kong to comply with the bare minimum of the latest exchange of information standard. It does not put Hong Kong at the forefront of international tax cooperation initiatives. As one of the 120 members of the Global Forum on Transparency and Exchange of Information for Tax Purposes for the OECD, Hong Kong is the only jurisdiction without a legal framework for entering into tiers. Hong Kong is going through a two-phase peer review by the Global Forum, which evaluates jurisdictions' compliance with the International Exchange of Information standard. Phase 1 of the peer review, Mr. President, was completed in October 2011. In December 2012, the Global Forum launched the Phase 2 peer review on Hong Kong, which evaluates Hong Kong's implementation of the Exchange of Information standard in practice and examines whether Hong Kong has taken forward the recommendations proposed by the Global Forum during the Phase 1 peer review process. If Hong Kong fails the Phase 2 peer review, Hong Kong may run the risk of being labeled as an uncooperative jurisdiction, which will be damaging to our position as an international financial center. In addition, other jurisdictions may also impose unilateral sanctions on Hong Kong. It is therefore critical for Hong Kong to have in place the legal framework for the tiers now before the Global Forum finishes the Phase 2 peer review in September 2013. Mr. President, I have reviewed the safeguards which have been proposed to be put in place in the bill, or any future agreements to preserve confidentiality and to prevent the passing of information subject to legal professional privilege to third-party countries. The safeguards, in my views, are at par with international standard and practice. On 18th of June 2013, the leaders of G8 met at Loch Earn in Northern Ireland. One of the achievements of the meeting was a commitment by the leading economies to shake up international corporate tax rules. The 10-point Loch Earn Declaration calls for tax authorities to share information automatically. It also urges countries to change the rules that led multinational companies to shift profits across borders to avoid taxes and require them to report what tax they pay where. Hong Kong may not be subscribing to these principles yet, but it would not be in Hong Kong's long-term interest to be labeled an uncooperative jurisdiction or a jurisdiction which attracts business due to its secrecy rules and opaque business and tax regime. Such types of offshore havens will soon have no place on earth. In conclusion, Mr. President, since the policy direction of the bill is clear and equitable, and it is fairly and reasonably drafted, I would urge my honourable colleagues in this chamber from across the parties to support this bill. Thank you, Mr. President.
李慧琼議員。
主席，2008年金融海嘯之後，好多西方國家都面臨嚴重嘅財政赤字，佢哋千方百計增加財政收入，而不斷提高稅務交換資料嘅廣度同深度肯定係方向之一。大家都記得09年4月喺倫敦峰會上邊20國集團同意打擊避稅天堂。OECD 隨即公布3種名單，即係黑名單、灰名單同埋白名單。當時法國曾經要求將香港同埋澳門列入作灰名單，即係代表呢個地區屬於打擊避稅不足地區。消息傳出引起好大嘅震動，因為香港作為國際金融中心、貿易同埋航運中心，一旦被列為灰名單會產生嚴重嘅後遺症。後來透過中央政府嘅協助， 極力阻止本港被列入灰名單，結果呢係有一啲其他嘅地方呢被染灰，而本港呢就避免跌入灰名單。香港呢亦都爭取到寶貴嘅時間呢，修改相關嘅法例，回應國際社會嘅關注。喺2010年，政府修訂咗稅務條例，令到經合組織稅收協定範本2004年版本中有關資料交換嘅條文呢得以喺香港落實。實際上呢就係讓稅務局呢可以因應全面性協定夥伴提出嘅要求，收集同埋披露某啲納稅人嘅資料，即使有關資料呢並不關乎本地稅務事宜。呢個做法呢同國際標準接軌，而香港政府嘅努力呢亦都得到國際社會嘅認同。2011年10月喺經合組織有關稅務透明化同埋有效資料交換嘅全球論壇上呢通過咗香港嘅評估報告，對香港致力提高稅務透明度嘅工作呢係予以肯定。而喺法例修訂之後呢，香港亦都採用咗國際性嘅資料交換準則，對擴大本港全面性避免雙重課稅協定網絡呢有好大幫助。至今呢，香港已經簽咗據我了解係29份全面性嘅協定。而喺2010年呢，法例修訂之前呢，其實香港只係簽訂咗5份嘅協定。到咗最近呢， G8 元首喺北愛爾蘭召開峰會嘅時候呢，與會者其中一項共識呢，就係要聯手打擊係跨境逃稅或者跨境避稅，同時促請各國修改法例，令到而家屬於合法嘅避稅行為呢都有機會變成非法。雖然喺峰會裏邊提出好多措施，都未列出具體細節，不過呢，外界預計呢9月喺聖彼得堡舉行嘅 G20 峰會呢，或者會簽署正式協議，所以呢，估計打擊避稅天堂嘅工作呢會陸續推展。今次政府提出稅務條例嘅修訂呢，係避免將香港列入為避稅天堂名單嘅第二波工作，因為最新嘅資料交換國際標準裏邊呢，係要求一個稅務管轄區同其他稅務管轄區呢應該同時具備全面性協定同埋交換協定兩種資料嘅交換工具。針對呢個標準呢，喺全球論壇將喺今年9月呢再進行第2階段嘅評估，所以呢，喺而家完成協定嘅法律框架呢係十分重要。可以預計呢，國際社會對於稅務資料交換呢只會不斷提高要求，亦都不斷收緊評核嘅準則。相信香港呢日後呢都會面對一輪又一輪嘅評核，而民建聯嘅立場係支持最低度嘅修訂，以符合資料交換嘅制度，令到香港能夠喺通過不同階段嘅評估，避免受到避稅天堂嘅指控。主席，喺過去多次相關討論裏邊呢，議員基本嘅立場都係相同嘅，就係喺稅務資料交換呢個問題上呢，我哋係唔需要超英趕美。喺國際社會嘅要求底下呢，香港呢一個細小而開放嘅經濟體，只需要喺最後嘅階段呢符合最低嘅要求，避免跌入避稅天堂嘅名單當中。咁背後嘅理據當然大家都理解啦，因為香港稅率低、稅種少，喺資料制度嘅框架底下呢，相信呢係香港企業呢係會係不斷被要求呢係提供資料，而香港可能向外要求提供資料嘅機會呢係相對少嘅。主席，所以民建聯呢係認同今次政府提出嘅修訂建議，亦都認為呢係符合最低嘅規定嘅要求。咁包括當局呢係考慮到對有關追溯性嘅評估同埋海外稅務調查嘅稅務資料嘅要求等等。咁另外政府都承諾呢，只會根據國際協定嘅條文同埋香港嘅法例呢，披露所要求嘅有關資料。面對國際社會對提高稅務透明度、防止同埋打擊避稅嘅期望越嚟越高呢，香港社會尤其是商界同埋中小企呢，其實都要提高警覺，亦都要有心理準備，因為喺好多國家眼裏邊呢，我哋香港都成日被定性為或者被認為係避稅天堂。呢個背後嘅想法呢，有兩大理由。第一呢，就係香港單獨執行地域管轄權，只對香港境內個人收益同埋企業利潤徵稅，而內地對於外商投資又一直實行有一系列嘅免稅政策，以致呢，如果 有香港公司嘅利潤主要係喺境外產生，好容易呢就形成咗雙重免稅。第二呢，就係香港稅項較少啦，稅率較低，企業所得稅呢亦都較其他國家低。加上香港唔使收利息稅啦、資本增值稅或者遺產稅等，咁亦都容易呢引起大量外國嘅資金流入。所以呢，為咗避免香港社會成為國際社會嘅眼中釘，或者被認為被視作不合作嘅稅務管轄區呢，我哋係有需要修改法例，配合國際稅務標準嘅基本要求。既然香港要履行國際社會嘅責任，配合國際稅務嘅標準，民建聯呢係促請稅務局要為我哋納稅人呢把好關。對於其他地區提出嘅資料交換要求呢，係取態必須從嚴，只要披露呢係要求最低限度嘅資料，同時呢確保交換嘅資料呢只向有關當局披露，以保障呢納稅人嘅利益，以回應呢企業嘅擔心。最後呢，民建聯係支持今日嘅修訂法例。咁考慮到政府同其他地方簽訂嘅全面性避稅雙重徵稅協定呢，更能夠促進香港商業活動嘅措施，我哋促請當局呢喺日後嘅工作重點呢係放喺擴展香港同我哋主要貿易同埋投資伙伴嘅全面性協定網絡。本人謹此陳辭，主席。
單仲偕議員。
Mr. President, I would like to return to my request for an independent oversight committee for the IRD. The administration's counter proposal does not properly address my concerns. The Global Forum on Transparency and Exchange of Information for Tax Purposes, the Global Forum, has recommended reinforce the legal framework to facilitate effective exchange of information. One of the vital enhancements to the framework would be establishing an independent oversight committee. The administration's proposals to extend the ambit of the Inland Revenue Department's Users Committee is unsatisfactory. The Users Committees would have limited access or exposure to information, since the IRD would provide all the reports, the breakdowns by the types of information requested, etc., to the committee. A flaw in this system is that the IRD would control all the information distributed to the Users Committees. Another discrepancy is that the Users Committees would not deal with the confidential information and will have no role in conducting reviews on individual cases. I fully support protecting taxpayers' privacy and confidentiality of information disclosed in EOI, but it is essential for someone to monitor the information the IRD shares. According to the administration, setting up an independent review panel under the law to monitor the handling of exchange information requests is premature. I disagree. In order to avoid complex scenarios in the future, it is vital that we take early precautions. In order to continuously maintain Hong Kong's reputation as an international financial center, we must strengthen the framework by constantly filtering and monitoring the systems in place. Creating an independent oversight committee would ensure the IRD would deal with the individual EOI's request in a fair and consistent manner, and all that actions taken and decisions made strictly adhere to the internal procedures and guidelines. Utilizing an independent oversight committee has several advantages. It is generally much more cost-effective compared with the forming and implementing something later. Also, since experts are involved, uninformed bias is kept to a minimum. The Independent Oversight Committee can also operate a meeting as an internal check between the IRD and the public. It is the role the committee can help the public understand technically complex issues by publishing reports that communicate the facts in ways the public can understand. The existence of an independent oversight committee can have impact on the quality of fairness and fact-finding even before the committee gains access to the relevant information. When research is done in the knowledge that an outside entity will be reviewing the research methods and findings, there is an increased sense of accountability. Government or corporate research entities must ensure the standard of the work is acceptable, especially because in the long run it will be more costly and time-consuming if they are forced to go back and correct mistakes when the Independent Oversight Committee detects errors or deceptions. As a past member of the Operations Review Committees of the ICAC, I understand how an Independent Oversight Committee should function. The ICAC ORC reviews every complaint made and cases investigated by ICAC, irrespective of the size and severity of the crime. Members of the ORC are entrusted with sensitive information in order to make appropriate judgments on cases reviewed. No investigation can be terminated with ORC consent. This successful relationship between ORC and ICAC has enhanced the productivity of ICAC. Why wouldn't RRD would form such a committees similar to ORC? President, I sincerely hope that the administration sees the necessity of forming such committees. Furthermore, the Security and Futures Commissions also have a similar setup. The SFC has a process review panel. I hereby urge the government to look into the matter. Thank you.
有冇其他委員要發言？如果冇呢，我現在請財經事務及庫務局局長發言答辯。喺局長答辯之後，辯論即告結束。局長。
主席，首先我要感謝2013年稅務修訂條例草案（下稱條例草案）法案委員會主席梁繼昌議員、副主席陳健波議員、各位委員同埋立法會秘書處同事所付出嘅努力，令審議工作得以順利完成。我亦要感謝各位議員支持條例草案喺今日恢復二讀辯論，並多謝李慧瓊議員同埋單仲偕議員剛才發表嘅寶貴意見。政府當局喺今年4月將條例草案提交立法會審議，法案委員會共召開咗6次會議，並邀請咗業界同埋相關持份者就條例草案表達意見。條例草案嘅目的係修訂稅務條例，讓香港可以簽訂獨立嘅稅務資料交換協定（我下稱交換協定），並優化現行全面性避免雙重徵稅協定（我下稱全面性協定）嘅資料交換安排，以符合國際標準。特區政府一直致力與主要貿易及投資夥伴建立全面性協定網絡，為跨境商貿活動提供明確嘅稅務安排同埋雙重課稅寬免，以促進本港同埋世界各地之間嘅貿易、投資同埋人才互通。截至2013年6月底，香港已跟29個稅務管轄區簽訂全面性協定，當中11個係香港首20位嘅貿易夥伴。香港作為國際社會中負責任嘅一員，一向致力提高稅務透明度同埋防止逃稅活動。所有香港簽訂嘅全面性協定中，均已加入資料交換條文。國際間對提升稅務透明度以防止同埋打擊逃稅活動嘅期望越趨殷切。根據經濟合作與發展組織稅務透明化及有效交換資料全球論壇（我下稱全球論壇）所述，國際最新嘅資料交換標準係一個稅務管轄區必須同時備有全面性協定同埋交換協定呢兩種資料交換工具。香港現行法例並不容許香港簽訂交換協定。香港作為全球論壇嘅成員，現正接受成員相互評估，藉以檢視香港是否符合國際嘅資料交換標準。香港第一階段嘅評估已於2011年10月完成。按全球論壇所述，香港可否通過第二階段評估，主要決定於是否具備簽訂交換協定嘅法律框架。假如香港未能通過第二階段評估，很可能會被國際社會視為不合作嘅稅務管轄區。呢個不但有損香港嘅國際聲譽，亦會削弱香港作為國際商業同埋金融中心地位同埋競爭力。而其他稅務管轄區亦有可能對香港作出單方面嘅制裁。 鑑於全球論壇將於本年9月審議香港嘅第2階段評估報告，我哋有必要盡快修例，使香港具備簽訂交換協定嘅法律框架，以爭取順利通過第2階段嘅評估。與此同時，為使我哋日後嘅全面性協定商議工作能夠有所突破，我哋需要透過法例修訂，以便在有需要時，協定下嘅資料交換安排可涵蓋不同嘅稅項種類，以及讓稅務局局長喺信納有關請求嘅資料關乎協定實施後嘅稅務評估時，可披露該等資料。在法案委員會會議上，我哋與委員就如何保障納稅人私隱及資料嘅保密性，以及建議修訂對納稅人嘅影響進行咗詳細嘅討論。我希望喺度總結有關資料交換安排嘅保障。首先，喺條例草案獲得通過後，政府喺兩種協定下嘅資料交換安排均會繼續採取現時高度慎密嘅雙重保障措施，以維護納稅人嘅私隱同埋所交換資料嘅保密性。在一方面，我哋會一貫地爭取將有關保障措施納入日後所簽訂嘅協定文本中。有關保障措施包括只披露可預見相關嘅資料，所獲取嘅資料必須保密，不得向第三司法管轄區披露資料等。而有關協定會以本地附屬法例嘅形式，經立法會以先訂立後審議嘅程序實施。另一方面，稅務資料披露規則會適用於日後簽訂嘅協定，作為本地嘅法定保障。有關規則訂明協定夥伴必須在資料請求中載述嘅詳情，以顯示其請求符合可預見相關嘅標準。至於條例草案中關乎披露限制嘅建議，正如我哋喺法案委員會會議上清楚表明，我哋無意偏離現行就交換嘅資料施加限制嘅政策，即向協定夥伴披露嘅資料必須關乎於協定條文實施以後嘅任何期間。我哋建議微調現行嘅披露限制，目的係容許在有關協定實施前產生嘅資料也可以進行交換，但大前提係稅務局在審視過協定夥伴在資料交換請求所提供嘅詳情後，認為有關請求符合可預見相關嘅標準，而所要求嘅資料係關乎於有關協定實施以後嘅任何期間所施行有關協定嘅條文或執行協定夥伴嘅稅務法律。藉住放寬喺資料交換所涵蓋嘅稅項種類，我哋可望有更大彈性去游說主要稅務管轄區與香港開展全面性協定嘅商討工作。喺條例草案獲得通過之後，我哋實際上會採取正面列載嘅方式，於每份協定列明所涵蓋嘅稅項種類。有關協定將透過立法會嘅先訂立後審議嘅方式實施，成為本地附屬法例。部分議員同埋代表團體曾就條例草案會否影響納稅人嘅責任或法律專業保密權表達關注。我重申，條例草案並無改變現行稅務條例下嘅紀錄備存規定，因此即使稅務局根據一項有效嘅資料交換請求行使其搜集資料權力，要求某人提供相關資料，該人亦沒有責任為着資料交換目的而向稅務局提供按稅務條例無需予以備存或超過法定備存時限嘅資料。 至於法律專業保密權，喺全面性協定同埋交換協定下嘅其中一項保障措施，係締約一方沒有責任提供會披露任何貿易、業務、工業、商業或專業秘密或貿易程序嘅資料，包括法律專業保密權所涵蓋嘅資料。有關對法律專業保密權所涵蓋嘅材料嘅披露限制，對稅務局係有法律約束力嘅。喺具體嘅操作層面，現行嘅稅務資料披露規則已訂有通知同埋覆核機制，讓當事人可向稅務局局長及財政司司長提出修訂行將披露嘅資料。如任何人士因任何行政決定而感到受屈，可向法院申請司法覆核。我哋認為現行機制已平衡各方面嘅因素，例如個人私隱、資料交換嘅有效實施同埋國際條約嘅義務。為咗回應法案委員會有委員就稅務局遵從保障措施嘅關注，我哋樂意擴展現時稅務局服務承諾關注委員會嘅職權範圍，讓有關委員會檢視稅務局定期提供關於資料交換請求嘅服務，以及處理上訴嘅情況。具體嚟講，稅務局會定期向服務承諾關注委員會報告其資料交換嘅表現，例如接獲資料交換請求嘅宗數、所要求交換資料嘅細項分類資料、處理狀況、接獲上訴嘅個案數目，以及有關人士提出嘅投訴數目等。然而，稅務局不會向服務承諾關注委員會披露個別資料請求嘅詳情，以符合全面性協定或者係交換協定嘅保密條文。有關條文已實施成為本地法律。事實上，我哋現時已就資料交換請求設立通知同埋覆核機制，讓當事人可以資料與事實不符或與其本人無關為理由，要求稅務局局長修訂行將披露嘅資料。如該人仍不滿意，可向財政司司長提出覆核嘅要求；如該人仍感受屈，可向法院提出司法覆核。有關安排一直行之以有效，亦為呢個納稅人提供保障。我哋認為有關擴展稅務局服務承諾關注委員會嘅職權嘅建議，已能有助提升對稅務局處理資料交換嘅監察，亦都平衡咗各方面嘅因素，例如資料交換嘅有效實施同埋國際條約嘅義務。部分持份者關注到日後香港所接獲嘅資料交換請求會隨之增加，因而對我哋嘅公共財政資源造成影響。參考咗其他稅務管轄區嘅做法，我哋現時嘅構想係考慮向提出請求方收取就索取及獲提供所要求嘅資料所產生嘅非一般成本嘅費用，而一般執行本地稅務法令所產生嘅成本，則由稅務局自行承擔。今後喺推展全面性協定或交換協定中嘅工作時，我哋會一如既往，讓相關持份者參與其中，包括不時諮詢商界同埋專業界別，透過稅務局網頁向公眾公佈即時開展嘅商討工作，喺有需要時與個別團體會面，以及定期向稅務聯絡小組匯報。喺未來嘅日子，我哋會繼續爭取擴展香港嘅全面性協定網絡。與此同時，我哋會因應一些稅務管轄區嘅訴求，而與之開展交換協定嘅商討工作。 我哋亦會不時檢視已生效嘅協定，以便與協定夥伴嘅主管當局提出任何有關協定實施嘅問題。隨住國際社會對提升稅務透明度及多邊合作嘅期望與日俱增，政府當局將因應在全面性協定同埋交換協定框架下所得嘅交換資料經驗，審視香港嘅資料交換安排。我哋會密切留意20國集團及經合組織喺推動自動或自發嘅交換稅務資料方面嘅發展。鑑於國際標準嘅不斷演變，我哋會繼續與香港持份者保持溝通，探討相關嘅政策同埋法律事宜，以期為香港訂立一套可持續發展嘅資料交換模式。主席，總的來說，法案委員會支持條例草案嘅建議。我懇請各位議員支持通過條例草案，讓有關嘅建議可以盡快落實。主席，我謹此陳辭，多謝。
現在各位提出嘅待決議題係2013年稅務修訂條例草案，予以二讀。現在付諸表決，贊成嘅請舉手，反對嘅請舉手。我認為議題獲得在席議員以過半數贊成，我宣布議案獲得通過。
2013年稅務修訂條例草案，
全體委員會審議階段，本會現在成為全體委員會。現在各位提出嘅待議議題係以下條文納入2013年稅務修訂條例草案。
第1至9條。
有冇委員要發言？咁現在各位提出上述待決議題，付諸表決。贊成嘅請舉手，反對嘅請舉手。我認為議題獲得在席委員以過半數贊成，我宣布議案獲得通過。全體委員會現在回復為立法會三讀